Mr. President, members of the court, it is an honor to appear before you and to represent the Gambia in these proceedings. Before the break, you heard the terrible details of the genocidal acts perpetrated by Myanmar's military and security forces against the Rohingya group in Myanmar's Rakhine State. Now, and in the remainder of the Gambia's presentation today, you will hear how these circumstances not only require, but compel the indication of provisional measures under Article 41(1) of the court's statute. The standards that guide the court in ruling on the Gambia's requested provisional measures are well established. First, the court must be satisfied that it has prima facie jurisdiction over the dispute. I will address the elements of that requirement. Second, the rights asserted by the Gambia must be at least plausible, and there must be a link between those rights and the measures requested. Professor Pierre Dargent will speak to this. Third, there must be a showing of urgency and a risk of irreparable harm, which my colleague Paul Reichler will amply demonstrate. Finally, Professor Philippe Sands will identify the specific provisional measures that are requested and explain why they are required. Now, with the court's permission, I will turn to prima facie jurisdiction. The Gambia has invoked the court's jurisdiction pursuant to Article 36(1) of the Statute of the Court and Article 9 of the Genocide Convention, which provides disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute. Both the Gambia and Myanmar are parties to the convention. Myanmar deposited its instrument of ratification on 14 March 1956, and the Gambia deposited its instrument of accession on 29 December 1978. Pursuant to its terms, the convention became applicable between the parties 90 days thereafter. Neither Myanmar nor the Gambia entered any reservation to Article 9 of the convention. Both parties to this dispute have, therefore, consented to the court's jurisdiction over disputes between the contracting parties on the interpretation, application, or fulfillment of the Genocide Convention. Because the Gambia has invoked jurisdiction pursuant to Article 9 of the Convention, the court must determine whether the acts complained of are prima facie capable of falling within the provisions of that instrument, and whether, as a consequence, the dispute is one which the court has jurisdiction ratione materiae to entertain. As set forth in its application, the Gambia has alleged that Myanmar is responsible for committing genocide, for attempting to commit genocide, for conspiring to commit genocide, for inciting genocide, for complicity in genocide, and for failing to prevent and punish genocide. Clearly, the acts complained of fall directly within the provisions of the convention. The allegations are specific and reflect, and in many cases repeat, the conclusions reached by the United Nations fact-finding mission and other authoritative UN bodies, that acts of genocide have occurred and are likely to continue to occur. There can be little doubt that the court has jurisdiction ratione materiae. Further, there is an unambiguous dispute between the parties. As the court has frequently held, a dispute between states exists where they hold clearly opposite views concerning the question of the performance or non-performance of certain international obligations, and where the claim of one party is positively opposed by the other. The existence of a dispute is a matter for objective determination. If the parties have made explicit reference to the specific treaty in dispute, as the Gambia has in fact done in this case, such an express specification would remove any doubt about one state's understanding of the subject matter in issue and put the other on notice. Mr. President, Myanmar was put on notice of this dispute under the Genocide Convention on several occasions, and it acknowledged receipt of that notice prior to the Gambia's filing of this case. From 5 to 6 May 2018, the member states of the Organization of Islamic Cooperation, OIC, including the Gambia, met at a ministerial level in Dhaka, Bangladesh, where, among other actions, they promulgated the Dhaka Declaration. That declaration expressed concern over the systematic, brutal acts perpetrated by security forces against the Rohingya, which constitute a serious and blatant violation of international law, and sought to address the accountability issue for the violations against the Rohingyas in Myanmar through the formation of an ad hoc ministerial committee to be chaired by the Gambia. In response, Myanmar's Ministry of Foreign Affairs issued a press statement 3 days later to categorically reject the declaration's description of events in Rakhine State as state-backed violence. Myanmar was thus on notice as early as May of 2018 of the newly formed OIC Ad Hoc Committee on Accountability for Crimes Against the Rohingya, chaired by the Gambia, and its allegations of state-sponsored violence against the Rohingya. In September of 2018, the United Nations Fact-Finding Mission on Myanmar released its first series of reports in which it found evidence of genocidal acts and genocidal intent attributable to Myanmar in the context of its crimes against the Rohingya. Myanmar dismissed those findings as biased. The Gambia, on the contrary, made clear in its remarks at the United Nations General Assembly later that month that the Gambia has undertaken to champion an accountability mechanism that would ensure that perpetrators of the terrible crimes against the Rohingya Muslims are brought to book. On 2 March 2019, the member states of the OIC held another ministerial level meeting at which they, including the Gambia, adopted a resolution on Myanmar's crimes against the Rohingya, which emphasized that accountability was necessary for preventing genocide, and endorsed the recommendation of the ad hoc committee chaired by the Gambia to hold Myanmar accountable under the Genocide Convention. In response, Myanmar again denied responsibility and criticized the resolution as an interference with its sovereignty. On 16 September 2019, the United Nations Fact-Finding Mission submitted its second report. Myanmar rejected wholesale the Fact-Finding Mission's report, which welcomed the efforts of states, in particular the Gambia, to encourage and pursue a case against Myanmar before the International Court of Justice under the Genocide Convention. The Gambia, in remarks before the United Nations General Assembly on 26 September 2019, at which Myanmar was present, confirmed that the Gambia is ready to lead the concerted efforts to take the Rohingya issue to the International Court of Justice on behalf of the Organization of Islamic Cooperation, and we will call on all stakeholders to support that process. As a global community with a conscience, we cannot continue to ignore the plight of the Rohingya. On 11 October 2019, in furtherance of its support of the conclusions of the UN fact-finding mission, the Gambia's permanent mission to the United Nations sent a note verbal to Myanmar's permanent mission, expressing the Gambia's concerns regarding the ongoing genocide against the Rohingya people in violation of Myanmar's obligations under the Genocide Convention. Noting Myanmar's rejection of the fact-finding mission's report, the Gambia emphatically rejected Myanmar's denial of its responsibility for the ongoing genocide against Myanmar's Rohingya population and its refusal to fulfill its obligations under the Genocide Convention and customary international law. The Gambia concluded its note verbal by declaring, with somber reflection on the goals of the Genocide Convention and its obligations on all states, the Gambia understands Myanmar to be in ongoing breach of those obligations under the Convention and under customary international law. The Gambia insists that Myanmar take all necessary actions to comply with these obligations, including but not limited to its obligations to make reparations to the victims and to provide guarantees and assurances of non-repetition. Myanmar received the Gambia's note verbal on the date it was sent. Myanmar confirmed this by means of its own note verbal to the Gambia's mission to the United Nations, sent from the same email address to which the Gambia had sent its note verbal. Although the court has previously held that a formal diplomatic protest is not required, here there was one, in addition to direct statements and actions in multilateral settings and additional indicia of Myanmar's awareness of this dispute under the Genocide Convention. Mr. President, members of the court, the Gambia's case against Myanmar prima facie falls squarely within the provisions of Article 9 of the Genocide Convention. A dispute over Myanmar's failure to fulfill its obligations under the convention plainly exists. And Myanmar was well aware of this dispute prior to the filing of the application. Mr. President, members of the court, there can be no doubt that the court has prima facie jurisdiction over the Gambia's claims. I thank you and the court for your kind attention and ask that you call Professor Pierre Dargent to the podium.